Legally Speaking with me, Tarun Nangia. Justice Vibhu Bhakru and Justice Amit Mahajan of the Delhi High Court have given an order whereby they have ordered the Oberoi hotels, or the East India hotels, as it is also called, to pay 13 crores as duty for importing a private aircraft. This is a Hawker aircraft that they have imported, for which they have to pay duty on. Now, why did this happen? What are the details? We'll get into it. I have with me Advocate Malak Bhatt, who joins me on this. He is a partner with NM Law Chambers. We'll go and understand this judgment, because there is an increasing use of private jets by many companies in India. Is it an interesting aspect to delve into? And let me welcome Malak Bhatt. Thank you so much for your time.
Thanks.
And if you could just explain that Justice Vibhu Bhakru and Justice Amit Mahajan explained in detail why they've asked Oberoi and East India hotels to pay 13 crores. What is this aircraft? What happened in court? Could you just explain an introduction details to us?
Sure. In fact, as you rightly said, this judgment has actually caught a lot of attention, because in our industrial sector, we have a lot of companies, a lot of big conglomerates who use aircrafts for private services, for charter services, for passenger services of their own employees. And this judgment, to that extent, will definitely have a impact on how they treat these services amongst their companies, because a large aspect of how they treat customs is that they seek an exemption at the time of importing the aircraft. So let's just loosely understand what the facts were. In this case, EIH, as you rightly said, imported an aircraft in 2006. And when they imported the aircraft, they first obtained a DGCA license, a permit from the Civil Aviation Director General to get the aircraft into India. And as part of the Customs Act, there is a notification which says that you can seek exemption from payment of customs duty if you meet certain conditions. Now, the two conditions mentioned herein, and this is condition number 104 of the customs notification, says that the aircraft has to be used for non-scheduled passenger services or non-scheduled charter services. Now, as we all know, scheduled services are those which are largely being run by commercial aircrafts, where the aircrafts have to operate on a particular timeline on a particular route. Non-scheduled, on the other hand, are those aircraft which can fly at any point of time, which do not have a set route or a set manner in which they have to fly between two cities. So any kind of non-scheduled services, either passenger or chartered, can be exempted from the payment of customs duty. And while you do so, the company which is importing this has to give an undertaking that it is for the purpose of either passenger non-scheduled services or charter non-scheduled services. And if I fall foul of my undertaking, then I will obviously be liable to pay the customs duty. Now, so what happened was 2006, the aircraft comes in. It is an admitted position that EIH was using this for the purpose of their directors, of their employees, of key managerial persons who were using the aircraft for business purposes from going from one city to the other. In 2008, the customs authorities issued them a show cause notice saying that, look, we find that you are not using this aircraft for the purpose of non-scheduled passenger services as you had undertaken before us that you were. So you are in violation of your own undertaking of the condition. So why don't you pay the customs duties? Kindly show cause. In 2010, the Customs Department, after taking a reply from EIH, went ahead and confiscated the aircraft. So in fact, as we speak, the confiscation order stands resurrected because of the High Court order. So what in 2010, when the confiscation order was passed, the customs authority said either you pay the customs duty or this aircraft remains confiscated by us for non-payment. EIH appealed before the CESTAT. CESTAT granted a stay at that time. In 2020, CESTAT confirmed the customs authority order, which today also further stands confirmed by the High Court. Now, interestingly, what has happened is that the High Court has gone into two critical issues. One, what is the definition of non-scheduled passenger services? And what are the requirements that you have to meet for that? Secondly, when your DGCA license is subsisting, there is no question raised by the DGCA itself with respect to the undertaking that you've given for that, for actually getting the aircraft into India. Can the customs authority or the court, while dealing the customs duty, deal with the aspect when there is no question by the actual licensing authority? Now, the tribunal had largely held that for the purpose of non-scheduled passenger service, it has to be the tariff that you charge has to be made public. The services of a non-scheduled aircraft has to be made available to the public, even though it is for passengers used by a particular company for limited use. It still has to be kept open for the public to use. You have to publish the tariffs that you will be levying for flying the services. And most importantly, it has to be at a remuneration. It cannot be free of cost. It has to have some remuneration for using the aircraft. Now, the Delhi High Court does not agree with two out of the aspects. The Delhi High Court says, sorry, the tribunal was wrong while dealing with this aspect because it should not have asked for a publication of the tariffs. It should not have asked for the availment of the services to be made open to the public. However, we agree that this should be at a particular remuneration. And if the services are being used by any person without making any payment or without any remuneration, then it will not be considered as a passenger service. Now, let me just break this down here before we go ahead. The Delhi High Court on the first issue, because that was the principal argument that Mr. Ganesh, the senior advocate appearing for EIH, had raised, is that, look, if the agency which had allowed me to bring this aircraft into the country has not questioned the license, the undertaking that I've given there, because even under the aircraft rules, at the DGSTA stage, EIH had given an undertaking that I am using this for non-scheduled air transport services. The term used under the aircraft rules is air transport service. So this is a non-scheduled NSOP, non-scheduled operator for passenger services. If DGCA since 2006, because also mind in fact that they were replacing an older aircraft. If from 2006, since the time the aircraft comes in, till 2022, when the High Court decides the matter, DGC has till date not raised a single query. The Customs Authority is not someone to go into this issue of whether there's a violation. The court said, sorry, that may be so at the civil aviation level, but to avail benefit of the exemption under the customs rules, you have made an undertaking that you are using this for passenger services. Therefore, we can very well go into that question and see that whether you are in violation of that condition or not. Secondly, on this issue of interpreting notifications, the Delhi High Court went into the aircraft rules. It saw the definition of what is termed as aircraft transport services under the aircraft rules, and it read in the definition of air transport services within the requirements of customs notification. Now, the requirement there is that a flight and aircraft can be used for the purpose of non-scheduled passenger services if it is used by any person, and that includes directors, associate companies, group companies, employees of the companies, etc. But the term there used is only when there is for any kind of remuneration whatsoever. The term is very wide. It doesn't say for remuneration. It says any kind of remuneration whatsoever. So the court said for whatever it may be worth, there has to be some remuneration. Here, admittedly, the person who's using the flight is not paying anything. So while there may not be a boarding pass, there may not be a ticket issued by you, there may not be a publication of tariff, the services may not be open to the public. While all 95% of the conditions are left out, the 5%, which is remuneration, has to be there. Since EIH was not availing remuneration from its employees, directors, etc., they were made to pay this duty. They said, why either you pay the duty.
Basically, if we break it down, in 2007, East India Hotels / Oberoi Hotels acquired a Hawker 850 XP aircraft.
That's right.
This is a medium-sized aircraft that can sit up to 8 people.
8 people, yes.
So maybe for, this is assumption, maybe because they run such a large hotel chain, they may be providing charter services. This is a presumption. But they did not go through the legal processes that were required for them to avail exemption. And that's why the court ruled. So first you said the CESTAT, which is the Customs, Central Excise and Central GST. They ruled against them. Yes. Then they appealed to the Delhi High Court. And there now they have lost because the court is saying that no remuneration was paid.
Yes.
Just for our understanding, if even the directors would have paid some remuneration or people using them would have paid any remuneration, that would have resulted in that they should, they could have availed exemption from paying duty.
Absolutely. And in fact, as you rightly said, the term of the notification is so wide. It uses the term any remuneration whatsoever. So there is no benchmark on what the remuneration could be. It could be 1 rupee, it could be 100, it could be 500. It may as well be a deduction from someone's salary on a monthly basis. to say this as an employee of the company is a deduction that we will avail towards any aircraft service.
So now does it mean two things? That now the aircraft is impounded unless they pay, or should it will be, in what conditions can it be released now?
Well, if you ask me very frankly, I believe this order will be challenged in my understanding, because the issue of whether the adequacy of remuneration can be gone into in the first place, and what will be that remuneration. Because there have been judgments in the past where, for example, the Reliance Transport case, which is cited in the judgment, there was some understanding with the company which was using the aircraft under a lease agreement where they were paying 5% of the total cost from the company which had actually imported the airline. So they said very well, there is some kind of remuneration, so the import exemption will apply. In this case, can there be some mechanism where EIH will ultimately be able to show that, look, there is some element of the remuneration which is being paid by the persons who are using it in any form, because the term used is whatsoever. And if the term is so broad, does it have to be monetary consideration to be paid to the hotel for the use? Or can it be any other ancillary services, any inter-se agreements which can be read as a remuneration? So on that issue also, I believe this matter will travel to Supreme Court.
Mr. Malakpat, I want to ask you, does this have implication for many companies? Because in India now, large companies all have private aircraft. They all fly their senior executives on a routine basis in these aircrafts. Do you think they all will be watching this case?
Oh, absolutely. In fact, I believe amongst the large corporations, conglomerates, this is going to be a heated issue, because most of them, from what I understand and I know, are using aircrafts for especially the CEO, the CFOs, or the KMPs on a basis which was similar to EIH. While there may not be a backing of an agreement of a remuneration, they will, if not at least follow the case, also have to think back on how they will take this forward to ensure that their exemption does not run out. And it will be a very interesting issue to see how this pans out in the Supreme Court, because this is going to be a contested topic for everyone who's today using an aircraft, especially on the private side, because that's how.
Also, there is a problem, because what you're saying is, unless they get a stay order from the Supreme Court, this Hawker 850 XP aircraft with 68 people will be not operational.
No, it will be staying on the ground.
It will be staying. So that is also a loss for somebody who's using it.
Loss for somebody. And in fact, a similar situation may be entailing someone else who's also following the same route. So they will also have to think back as to how they consider their remunerative exercises, or how they fall within this clause of having some remuneration at the time of using the aircraft. So, and that issue, in fact, I may just point one very important thing, is that industries across India today are using services of privately owned aircrafts for mostly charter services without remuneration. And that's the standard practice, because the purpose of this non-scheduled operator flights to come in was ease of travel. So if the exemption requires remuneration, it kind of falters the fact that there is going to be remuneration which has to be necessarily charged by the company from its own employees. So it will require some look back at the Supreme Court to see how they deal with it, and it's going to be very interesting for everyone to watch.
Tell me one thing, in India now, it is fairly not, earlier the biggest companies used to import, aircraft for private use, private as in the company use. Now it has become common, because so many listed companies have a lot of cash on the books. They do buy private jets. We don't have as many as America. This trend is still catching on, but I think the number is fairly large in India now. What issues come to your mind when you think of this? Because I think, at least in the case of Oberoi East India Hotels, some documentation which they should have done, they have not done, and that's why this order. Otherwise, I think they would have been able to avail exemption, isn't it? Do you think it is a case of documentation that was not done?
So I believe it's your question can be answered at two fronts. Number one, if possible legal advice at the time of how to interpret this condition to ensure that the requirement
when they bought it,
at the time when they bought it, okay, that whether what compliances will be required to ensure that all conditions are fully met, number one. And number two, at the time of claiming exemption, because see, the understanding of exemptions in tax law is that exemptions are always strictly interpreted. But once you fall in the exemption clause, then it has to be liberally construed in favor of the assessor.
Basically, if Oberoi, so you complete, then I'll ask you.
So the idea is, had Oberoi in fact gone back to the drawing board with a lawyer or with its legal team and said, very well, this is the requirement of the clause, Are we meeting the requirement of meeting the remunerative exercise? Are we falling compliant with our undertaking that we've given to the customs authorities? Do we have a defense to the ABC question that may come? At the preemptive stage would have actually helped in defending this case probably at a larger threshold. And that's not only for this company, it may be also then which will be helpful to the entire industry, India Inc. at all.
The way Oberoi is approaching this case, the company was at least certain that it has committed no wrong and it rightfully deserves a duty exemption.
Absolutely.
That's why they contested in CESTAT. That's why they've contested in Delhi High Court. And as you're saying, they may be considering the option to contest in the Supreme Court of India.
I believe so. Because their stand was crystal clear on the law.
Interesting. Tell me one thing. Now, they bought an aircraft in 2007. We are in 22, which means 15 years have passed, and this case is still on. Do you think a large amount of time has been taken in the legal proceedings, which could have been settled in a couple of years?
Well, I mean, unfortunately, these are the vagaries of litigation that even tax cases go on for about 15 years.
Yeah, because this is an open and shut case of legal interpretation.
You're absolutely right. The only thing is that because of the pendency at the CESTAT level and the time taken for understanding, because see, unlike a pure tax case, even at the CESTAT level, if you read the judgment also, there are nuances about how the aircraft rules are read, how the notifications of the DGCA, how the manner in which the laws regarding civil aviation are interpreted by that authority are today being interpreted and understood by an authority which is only expert in tax. So because of that intermingling, probably even for the CESTAT, it was a nuanced case. It was something which was being dealt with to understand what remuneration would be. Are we looking at the DGCA rules properly? So probably that time, you're right, the time was quite large, but it's not a simple open and shut case as one would see it.
And by the time now this goes to Supreme Court and order comes, I think it will take another 6-7 months. So I think from starting to closure, we are talking of a period of 16 years for an aircraft import case.
Yes, but I thoroughly wish that this goes to Supreme Court, because this is definitely going to be an eye catcher for a lot of people, and it's going to impact a lot of tax. It's going to have a lot of tax implications on everyone who's going to have an aircraft who does not have a remunerative approach in the way in which they use the aircraft. A lot of these pinpointers will then start being the differentiating factors of any import show cause notices that come up to anyone, be it a DLF, be it an Oberoi, be it a Taj group, on how the aircrafts are being used.
No, if we speak into this whole issue concerns about non-scheduled passenger services or non-scheduled charter services. Right. If you offer both of these, then you don't have to pay a duty, right?
That's right.
So in the end, that is the condition number 104 of the notification.
Yes.
So they have to now go and establish that indeed it was used for passenger service, and that's why they're not liable to pay any duty.
Correct. Because see, what happens is 104 only uses these two terms. It does not go beyond that. For understanding what a non-scheduled service is, you have to go back to the aircraft rules. The aircraft rules uses only one term, non-scheduled air transport service, which means any air transport service which is not scheduled. And air transport service has been defined to include any transport vehicle of to carry humans, animals, anyone, but with remuneration whatsoever. And that's where the court came back to say, look, if we can't find deference or inference from the notification itself, we'll go to the aircraft rules to pull back a requirement of remuneration.
Okay. Do you think that for a fairly large economy like India, which is growing fast, a lot of corporates are now importing private aircrafts, these things need more clarity from the government itself? Because this also concerns the market of how executives travel. You know, India, a lot of airstrips have no passenger flights, which are used primarily by private operators.
Right.
There are a large number of airstrips which are, and they are used because many times many of these manufacturing plants are in rural areas with no good flight connectivity. Do you think, keeping all this in mind, there should be the Supreme Court judgment, of course, will give some clarity, but at the policy level itself, there should be clarity on such issues so that issues of interpretation don't occur or no problem crops up as far as the interpretation with reference to paying of duty is concerned?
So on first blush, the answer is yes, because the very concept of having a passenger service for private purposes is so that there is ease of accessibility for people who are importing it. Now, if a condition like remuneration is built into this, it from a business point of view or business mindset, it goes against the very rationale for which this exemption was granted. If one is to ask a big corporate saying, look, you are anyway importing, say, 10 aircrafts. The purpose of these 10 aircrafts are you have plants, you have machineries, you have large scale assets which are based in very remote areas. You need to travel to them. Now, if the mechanical team, the team which is on board, is required to pay remuneration for the purpose of taking that flight, for the purpose of development of India as a whole, because you're developing, say, a hydel project power plant at a place which does not have flight access anyway. A condition like remuneration in this is in fact counterproductive to the very sentiment of development and making.
Or if I ask you, many people have offshore fields, companies. Right. So from the mainland to you go into sea, 10, 15 kilometers where your what you may call maybe oil field is located. Right. And helicopters are used there.
Absolutely.
Also, so in fact, while I was talking to you, I came across this paragraph which you alluded to me when we started the show. The term air transport services defined under subrule 9 of Rule 3 of aircraft rules as under. Air transport service means a service for the transport of air by persons, mails, or any other thing, animate or inanimate, for any kind of remuneration whatsoever, whether such service consists of single flight or series of flights. So this line, any kind of remuneration, which means that, as you also said, that if I transport as a company my 30, 40 executives, it's also a part of remuneration that they get this facility, for this, which they may pay any kind of money. Correct. For which I will, and it could be consultants which I hire from abroad to work at my plant. They also may be using it. There may be not only employees, a bunch of other people who may be using it.
Correct. So, and which is where we will have to look upon how the Supreme Court looks at this, because it is counterproductive the manner in which remuneration today is fitted into this concept. Can it be 1 rupee, which is deducted from the salary at the end of your month to say at any point of time you will be using my aircraft services, so I'm deducting 1 rupee every month, which will count towards remuneration, because that then every company can do. One can always go back to the drawing board and start molding these agreements. But
we'll have to see, I think, Malak, how this case now goes in Supreme Court. We'll in fact follow it up, because I think there'll be a lot of points that we can then cover.
Absolutely. Yes.
As and when it's heard. But I really appreciate you joining us on this very interesting topic. It's a very different and interesting topic that we took up today. It has implications for corporates, because there are large sum of money involved as duties. 15 and 30 and 40 crores, because I think the size and the cost, 8 people, and the aircraft is not that large. So maybe the duty sum was low. The duties could, I think, grow manifold, given the price of aircrafts are 250 and 300 crores that a lot of people.
And even the duty component is rising. So the duty aspect on all these aircraft will also be increasing on a year-on-year basis.
Yeah. So appreciate you joining us, Malak. So this was Malak Bhatt, partner and founder from NM Law Chambers. And Malak, we would request your participation again when we take it again in when it goes to the Supreme Court. But thank you so much for sharing your perspective. Thank you. Thank you, viewers, for tuning in. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.